Hi, I'm Dan Smith of DPS Legal Counsel, and welcome to today's video. Today I'm going to be talking about contracts for businesses, and particularly clauses in contracts that choose arbitration versus litigation in the event of a dispute. These are typically called arbitration clauses, and we're going to talk just briefly about those today. Oh, by the way, today I'm wearing a Baylor University cap in honor of my son, who is a graduate student in the PhD program at Baylor in the English department, and is also a graduate assistant instructor there at Baylor. And I want to wear this cap today in honor of my son, and go Baylor Bears. Okay, so anyway, let's just talk briefly about arbitration clauses. If you've seen many contracts, read many contracts, you've run across an arbitration clause. And in fact, you've probably signed or agreed to a number of contracts that have arbitration clauses, maybe without even being aware of it. When you click on accepting the terms and conditions of online contracts for apps and various things, you've probably agreed to have your dispute, if you have a dispute, handled through arbitration. And so the difference between arbitration and litigation is, well, there are a lot of differences. The main difference is that with litigation, or going to court, you have a judge, you have a public forum. It's what you're used to with the resolution of disputes in the American system, which is you go to court and a judge or a jury decides your dispute. If you don't like it, you can appeal it to the next highest level of court, and on and on. With arbitration, you're essentially taking your dispute out of the court system and handling it privately with an arbitrator who is hired by the parties to decide the dispute. And typically, once the arbitrator makes a decision, the arbitration clause is probably going to provide that the decision of the arbitrator is binding. So there's typically no appeal from the decision of an arbitrator. Again, arbitration clauses are provisions in contracts. So the contract provision in your particular case or in a particular contract may vary from another provision in another contract, so you have to read them carefully. But in general terms, if you have an arbitration clause in a contract, you're going to be basically letting your dispute be decided by an arbitrator who will make that decision, and typically the decision is the decision. It's not usually appealable. So what are the pros and cons of having an arbitration clause? When you see one in a contract, or if you're preparing a contract for your business, do you want to have an arbitration clause? Well, some of the pros and cons. The often cited one of the pros for an arbitration clause is that arbitration is less expensive than litigation. And that is probably true, because litigation can be very expensive. But it's also true that an arbitrator can be expensive. It just typically is the case that arbitration is going to take a shorter period of time, and it's going to be less involved, less lawyer time generally, and so arbitrations generally are going to be less expensive than litigation. Another pro or another positive about arbitration is that it's typically a quicker process than litigation. And then on the con side, one of the negatives of arbitration is the one I mentioned, is with litigation, if you get a decision you're not happy with, you can typically appeal it to the next level. That's not going to be the case typically with accarbitration. And so when you're getting ready to sign a contract, or you're getting ready to prepare a contract, you need to kind of take all the pros and cons into account before you decide whether you want to have arbitration or not. And of course, one of the key points in an arbitration clause is how do the parties decide upon an arbitrator. And it's often the case that the provision will provide that each party will select one arbitrator, and then those two arbitrators will select a third arbitrator who will be the deciding arbitrator. But there are all kinds of contract provisions dealing with arbitration. If you're asked to sign a contract that has one, you just need to read it carefully, make sure you understand it. If you're preparing a contract, you have to decide whether you want to include arbitration versus litigation as the choice of dispute resolution in your contract. But these are some of the pros and cons that go into deciding whether you should have arbitration or litigation in your contract. So I hope that helps. This is a short video today, but I just want to kind of give you a little heads up about arbitration versus litigation as a dispute resolution provision in your contract. We'll talk to you next time. Thanks.